series of lectures we have. You can see she is trying to connect.
I've connected.
Thank you very much. It is my honor to introduce Assistant Legal Advisor, who looks like a custom officer because she understands all the of customs. And in case if after the presentation on the Nigeria Customs Service Act, you want to ask question on CA, she's also very, very competent on CA. She can give you some insight about what the CA is. We understand what CA is. So it is my honor to hand over the podium and the mic to Assistant Legal Advisor Uche for her presentation on Nigeria Customs Service Act 2023. Our Leonard.
Okay. Hi, everybody. Good evening.
The floor is yours.
You can hear me, right?
Yes, we can hear you.
Perfect.
Okay, all right.
Yes, we can hear you.
Great, thank you. Good evening. So let me see if I can share my screen. I've prepared a brief slide. You can see my screen, right?
Clear, sir.
You can see my screen. Okay, sorry, I'm just trying to. Oh God, what's going on? Sorry, my screen is misbehaving. I'll do it. Okay. I'm trying to project. Okay, so yeah, so I'm going to give you, I'll just skip the background part of the act. I don't know, are you guys interested?
Absolutely.
Okay, you're interested? Okay, fine. Okay, fine. Okay, so I've prepared this slide. So first of all, you all know that the SEMA that you were using was promulgated in 1958. And that's like a long time for the service to be using a law. That was absolutely outdated because obviously there's been advancements in economy, population, technology, but the law remained unchanged, and there has been a need for a modernized customs law. There has been several attempts to try to modernize the law, but they have all failed until the promulgation of the Nigerian Customs Service Act 2023. Now, this act came into force on 20th April 2023, when the former president, Muhammad Buhari, signed it into law. And it is official because it has been gazetted, and you can see that I have put the gazette number, which means that it is from 20th April 2023, the customs is expected to have started implementing the Nigerian Customs Service Act. The import of this is anything that happened before 20th April 2023 would be treated under SEMA, even if it is brought forth at this time. But if that event occurred before this date, then SEMA would be used to attend to it. But anything after 20th April 2023 is subject to the Nigerian Customs Service Act. Now, you would ask yourself, what is the purpose of this Nigerian Service Customs Act? It is intended to revamp the service, to increase revenue, and to boost operating administrative. The difference between the SEMA and the Nigerian Customs Service Act. Now, SEMA was divided into 13 parts. Customs Service Act is 33 parts. SEMA had 195 sections. The Nigerian Customs Service Act has 282 sections. SEMA had 3 schedules, but the Customs Service Act has 1 schedule because everything has just been compressed. 19 subsidiary legislations, that's regulations that were made from SEMA, but they have all been consolidated into the Act. So same changes have been in the Act to meet up with the existing realities of present day operations. In the Act, you will see that punishments have been increased for crime and also prison term. Example, you would see offenses in the in SEMA that the fine would just be like 1,000 naira, 500 naira, 200 naira, which is not just in line with the current day realities. In fact, we used to use it as a tactic in court. You tell someone, just plead guilty. You can see that what your fine is just going to be like 200 or something basically inconsequential. But in this new act, you see that the punishments are just in line with present day. Now, the beginning of the act starts with the establishment of the service. The most important thing to note is if you look at section 2, is that the service is now a juristic entity. What does this mean? It means that the service can now sue or be sued, and it can also enter into legal agreements. This was not the case before, because before, if you wanted to sue the service or if the service wanted to do something, they would have to go through the board. But now the service is now a legal entity and now has rights and responsibilities. You can also see that section 3 is where the legal status is now away from the board. Then functions and powers of the service, same thing. The powers and duties are now directly assigned to the service, which is different from the SEMA, where it will be delegated through the board. The concept behind this idea was that most times, the board, they're very busy. How many times do they really get to sit and all of that? And before they would now be able to delegate their powers or whatever it is, whatever the offense or transgression or action that you want to carry out would have already passed. So now the service on its own now has powers and duties. But if you take a look at section 5 of the Act, it specifies the powers that this, as in the service has to get board's approval. So it doesn't mean that because the service has now been given powers and duties directly, that they still don't need to get the board's approval for certain actions. If you take a look at section 5, those powers are specified. Then one of the key responsibilities of the board in this new act is the formulation of general policy guidelines and regulations. What does this mean? It means that there are things that the law did not conceive. So it is not everything that can be contained in the law, but it has now been put into the act that the board can make regulations to provide for those things, and there are also things that you also don't want to codify in the law, because take a look at it. We said SEMA was done in 1958 and did not get changed till 2023. So imagine that maybe you have put a specific sum or something in the act. That means that you would have to change the whole law to be able to revise that. So this section 10(1)(a) now provides for the board to be able to make regulations, which means that if something has changed, they can now make regulations to meet up with that exigency. Then let's take a look at the governing board of the Act. The management committee is now provided for and their functions. It's not as if all of these things were not prevalent before, but they were not codified in law, but now it is specifically provided for in the law. And then the board membership has also been refined. Previously, you'd see that the board consisted of a lot of stakeholders. It has been trimmed down to include only relevant stakeholders, and also two representatives from the private sector can be drawn into the board, but their tenure is not unlimited. You have a term of 4 years, renewable once for another 4 years, and then you now pick out maybe 2 other people from wherever you so, from the private sector that you so wish. And then the supervision of the Federal Ministry of Finance, Budget and National Planning is still reinforced in the Act and is in section 12. But you'll see that even though the minister is the chairman of the board, he has to consult with the CG before he issues directives to make sure that whatever directive that is being issued is still in accordance with the Customs Act. Now, I think this is a very important and novel provision in the Act, which is Section 14, that provides for the appointment of the CG of Customs among career officers not below the rank of ACG. The SEMA did not have this provision, which means that anybody could have become CG. But now, because of the inclusion of this section, the CG can only be drawn from among career officers of the service. Another novel provision is also financing of the Services Act. Previously, it was 7% cost of collection, but now it's a minimum of 4% of FOB that has been introduced. This is a major innovation. But you can note, if you look at sections 18.2, that this 4% is not sacrosanct, which means that if the service can prove that the 4% FOB is not sufficient to finance their activities, if they make a case to the president can still adjust that 4% FOB. And then the tariff regime that is determined by the board will require approval by National Assembly. This is typical public service rules, and it's supposed to be made public on the Customs Service Handbook and also the website. Then we also have auditing of accounts, because when it comes to finance, you cannot just leave it open. I will eventually share this slide, so it's not like I'm rushing, but I was giving a time cap. Now, information. This act places an emphasis on transparency in alignment with the Freedom of Information Act. So the act is trying to make sure that information on customs processes are to be publicly available. But this information that is supposed to be publicly available is not just on the customs service itself. It is also mandated on those that are involved in customs formalities, whether direct or indirect. They are mandated to provide information freely, and this is provided for in sections 22. In line with the current world that we live in, we know that electronic data processing is the way forward. So the Act has conceptualized that and has provided that electronic data processing be the primary method for the exchange of data. But we also know the country that we live in, and we know that there are things like power supply failure, internet failure, etc. So paper can still be used in lieu of the electronic data processing method, but electronic data processing method is the primary method, and only when there are exceptional circumstances, then you will resort to paper. If you look at section 6 as well, you see that the service has an obligation to protect confidential information. This means that there's information that you would receive in the course of your duties that is considered confidential. It doesn't mean that because you have derived that information that it is now supposed to be exposed. There's an obligation for information that is supposed to be confidential to be protected. And this also beholds on officers. It's like sharing of information. You'll be subject to disciplinary measures if you violate this provision. And then section 28 provides for interagency cooperation. Now let's go to customs controls. You would note that in the Act, custom ports, airports, and wharves are now described as customs service controls. They are no more referred to as those previous names, but it is, when you talk about customs service controls, what you are really talking about is the ports, airports, and wharves. And you'll see that administrative procedures like risk management, joint inspection, PCA, joint border operation, which were things that the service was doing before, they're not new, but they are now specifically provided for in the law. The law is also mandated, the service is also mandated to maintain a risk register, and the risk management data is also confidential. The violation of this confidentiality of the risk management data attracts a penalty of 5 million naira or imprisonment for 2 years or both. This pays reference to what I said earlier about the Act now introducing stiffer punishments and fines. You can see that 5 million naira just for violation of confidentiality and 2 years imprisonment. Now, when you see that something says, so like now you see, it says 5 million naira or imprisonment for 2 years or both. What this means is that if you're found guilty of this offense, you can be asked to pay 5 million naira, or you can be sent to jail for 2 years, or you can be asked to pay the 5 million naira and still be sent to jail for 2 years. So you can see that the act is just really tough. Then single window was introduced into the act. The service is supposed to be the lead agency for the establishment and coordination of single window. It is provided for in your laws in sections 33. And also cooperation with other customs administrations is provided for in section 34 of the act. But this cooperation is subject to the signing of a CMAAA. You have to do a mutual service agreement. It is not just open and free for all. You don't just say, oh, this is customs, this is other customs, let's collaborate. There must be an agreement that would state specifically what the aims and objectives of the cooperation is. Then sections 42 provides for consultants. The service can hire consultants to give them advice on customs control measures, but these customs consultants cannot effect the duty. So what this means is that they can come into customs and give advice on a customs control measure, but they cannot implement that customs control measure. That is specifically tailored for officers. Now, document retention. For customs matters, it is supposed to be for 10 years. That means that the service is mandated to keep documents for 10 years, and also whoever is in possession of a custom documentation, if the service is asking you for it also, at least within a 10-year period from the time it occurred, you're supposed to be in hold of that document. But after a period of 10 years, both ways, the service cannot request for documentation from a trader or whoever after 10 years, and vice versa. They can also not request for that information because the time cap that has been placed by the law has elapsed. Then when it comes to appeals, 3 years is the timeline for appeal for documents relating to appeal matters. So when you start an appeal and it has finished 3 years after, the service and whoever it is that was engaged in that is expected to still be in possession of that documentation. And then when that time has lapsed, then there's no expectation from the law for you to be in possession of that documentation. Then there are some times that you see that people expect officers to do stuff that is regarded as special services. The CGC is empowered by this act to be able to issue regulations for these special services so that they can pay a fee, cost and exports. There's really, the differences are not a lot. So I've just picked out the parts for that you need to outline. Like I said, the most important things mostly is the penalties, because stiffer punishments have been introduced for offenses in the import and export domain. And now importers and their agents are mandated to report all importations and exportations. There's no excuse. It is provided for in the law. And it also provides for electronic transmission mediums, which is the same. It's just like a reiteration of the earlier fact. Electronic processing is heavily reiterated. And then for prohibition list, it is the president that holds the power to place items under prohibition, but he can also make exceptions if someone has applied for same, and that's provided for in sections 55(3). It was 15 days for uncleared goods, but in the new act, it has now been extended Now let's go to customs duties. Section 67 provides that declarants are mandated to ensure truthful and accurate entries, because that anything other than that would constitute an offense. And you would also note that in this new act, anybody can transact with the service. It doesn't have to be an agent. The act now opens it up to anybody to be able to conduct their own business by themselves. If you look at sections 75, the act now provides for delayed duty determination. We know that in the course of trying to determine duty, sometimes it is not timely. It takes a lot of time. Maybe you're trying to do examination or whatever it is, and it's taking time. The act has now provided that if duty is taking too much time and somebody wants to clear their goods, if they provide a guarantee, you can allow the goods to go pending when you can then determine duty and issue on the person, because whatever guarantee that they're providing is supposed to be in lieu of how much you're expecting their duty to be. So at least you have that guarantee to hold on to pending when duty is determined. And the service also reserves the right to investigate and ascertain the truthfulness of any declaration, which means that not because you have given a declarant has given a declaration, it doesn't mean that it is sacrosanct. The service has the right to be able to ascertain the truthfulness of that statement. So that's provided for in sections 77. Now, one of the new introductions in the Act is for liabilities. So if multiple parties are responsible for a customs debt, they are both jointly and severally liable. What does this mean? It means that as an individual, the person is liable, and the two of them or three of them or however many they be together, they are liable. So if you charge them to court, they can be found guilty or innocent individually or together. The service has provided a 14-day period for notification of customs debt. So when you find out that there's a debt that you want to issue, the Act has provided for a 14-day time frame. And then the payment of this debt is 30 days. So this is after the person has been notified, then they have 30 days to pay that debt, but they can make applications for extensions, and if it is granted, then the 30-day period no longer applies. And let's go to guarantees and securities. So the same thing, like I said before, if someone provides a guarantee, the service can permit payment deferment period for duties and fees. The service is now legally bound to take measures to recover its unpaid debts and any associated interest. So you can go to courts for recovery of unpaid customs duty, which is what we have been doing anyway, but it is now codified in the law. Now, there's mandatory guarantee and optional guarantees. There are certain transactions that involve customs licensed agents that require compulsory guarantee. That's provided for in sections 96. But following that, you'll see that there's also optional guarantee, which means that an individual that is transacting with the service can also choose if they want, because they want their transaction to be processed quickly, they can also provide a guarantee. This guarantee can take different forms. You know, before they would just say, oh, just bring a bank or something like that. But now, if you look at sections 98(1)(a) to C, you can see that there are different forms that it can take. But these guarantors must be pre-approved by the service. So it means that before the person can actually, the guarantee can actually be accepted, they've already been pre-approved by the service. Now, customs representatives. If you look at sections 103(1), which is what I talked about, business engagements with the service is now broadened beyond merely licensed agents. That means it is not only licensed agents that can transact with the service, anybody can. And that now cascades into sections 106(10). Because the service has now allowed individuals to transact with them, anybody that represents themselves as an agent when they are not an agent is subject to heavy penalties and fines. Another new introduction into the Act is AEO, Authorized Economic Operators. This just means that the people that qualify to be registered as AEOs would have simplified procedures available to them to be able to carry out their trade and do representation for their clients. Customs procedures. Sections 113 provides the steps that are needed for lodging different type of declarations with the service, because you know that there are different type of declarations that you can do with the service. Now, section 113 provides for the different steps. People would previously say, oh, why they used this method of declaration was because they did not know what the steps that they're supposed to take are. In the Act, it is elaborately provided for, so any mistakes would constitute an offense. And simplified declarations have also been introduced into the Act to be able to speed up trade processes, because it's a bit unfair to subject different type of importers to the same method of declaration. Someone that is doing transactions in billions and millions, and then you have someone in the hundreds of thousands, and it is the same very difficult process that is put for them. So now there's simplified declaration that has been introduced into the Act for low value transactions, and low value transactions has also been defined in the Act. And also another thing that was provided for is amendments. Previously, when you do your declarations, it's very difficult to find the way to amend that declaration, maybe an honest mistake, even though we know that's not really the case. But if you look at sections 115, it has provided for a way that you can amend your declaration within specific time periods after you have lodged same. Now, if we look at sections 119, it just talks about disposal of goods. This was previously contained in the Disposal of Goods Act that was a subsidiary legislation to the SEMA, but now it is codified into the Act that the service with court order can sell, dispose, or destroy goods. And if you look at the cases in subsections 119A to E, you can see the different cases. If these goods are abandoned, though, the importer of the good or the holder is the one that is going to bear the cost of this disposal, because typically it is the service that bears the cost of disposal of goods. But if you see that the goods are abandoned, then you would hold the importer or the holder of the good responsible for the cost of the disposal or destruction. Now, warehousing. One of the new introductions is that both the warehouse and the warehouse keeper must be licensed. If you look at sections 122, that's what provides for it. And then the service has control over this, both public and private warehouses. And sections 127 provides the measures that are put in place to maintain that control. Sections 126 talks about warehousing procedure and then the penalties for non-compliance. For if you look at unauthorized goods deposition, it is now a 3 million naira fine for the warehouse keeper. So also you see that the fines are really, really intense. And section 133 provides penalties for warehousing related offenses with fines ranging from 5 million naira to 25 million naira and increased prison terms. So you can definitely see that the fines and the punishments in this act are quite, they're quite very stiff. Now, the free trade zone. The service supervises the entry and exit into the free trade zone. The free trade zone is actually the mandate of NEBSA and OFSA, but the service supervises the entry and exit point because that's where you now say that you're crossing over from the free trade zone into the customs control area. So the service is supposed to man that to be able to know what's going in there. The service is mandated to collaborate with the agencies that are in charge of the free trade zone, and that's provided for in sections 134.5. Now, sections 134.6 imposes fines of 40 million naira or imprisonment for 5 years or both for contraventions in this free trade zone. Like a whooping 40 million naira. So offenses in that place, because they understand that if you're trading in that section, you're saying that your goods are not subject to duty. So if you contravene the actions that are there, the fines are up to 40 million naira, which is quite hefty. Now, the temporary admission procedure, we all know that there are goods that are intended for re-export that can come into the customs territory and get partial or total relief from duties and fees. These are goods that you're saying that the importation is not for rent or resale, but for specific projects. So TIP is usually issued by the service for high value items like oil rigs, ships, and special equipment, etc. But we all know that sometimes these things are abused. So the provisions of these sections are supposed to be heavily determined. Now, the goods under TIP is supposed to be for a period of 12 months, but there's possible extensions. And these extensions, if you ask for the extension, you are given an initial 1 year. If your application is granted, it is permitted for you to now ask for an additional extension, which would be 6 months. And if you ask for another extension, that's another 6 months, which means that the extension period is going to total a period of 2 years. And anything outside of that, if you still haven't achieved your aim, then it can now be either re-exported or converted to home use, and you pay the duty that is prescribed.
Please, I want you to go back to that TI clarification. You will be
No,
given
just so, no, wait, hold on. Note your questions. Let's finish, and then we'll take. Okay, thank you. Then we have cross-border e-commerce, postal and express shipments. So e-commerce is one of the things that has been incorporated into the Act, because we know that a lot of e-commerce has been going on, but obviously under SEMA 1958, there was no conceptualization of that, and provisions were not made to govern those activities. So they have now been introduced into the Act. You see express shipment has been provided for in sections 157, then export procedures, and then penalties for also improper exportation and failure to remit custom duties to the Federation accounts. Now, travelers and duty-free shops. Section 162 provides for duty-free shops, which is something that we don't really have in Nigeria, but now because we know that things are moving forward, so section 162 provides for that. So especially as the customs is mandated to collect duties, so this governs, the regulation of that. And also the dual channel system. Now the dual channel system is that system like when you travel abroad, that they have those 2 lanes, nothing to declare and something to declare. So this has also been introduced for travelers to simplify customs control. Another thing that has been introduced is personal search on travelers, but this is under specific conditions where there's suspicion that the person is probably maybe trying to smuggle or something, and the Act has provided those conditions. Now, I would say that a general rule of search is that it's supposed to be gender to gender. So that is male search male and female search female. But there are exceptions to this rule. That means that where there's a threat to national security and where there's a threat to an officer's life, then a man can search a woman can search a man. That means that in specific circumstances, then the general rule of personal search, that's body search, has now been traversed. But let's assume you're at the airport, you're a man, and there's a female that is approaching, and you have the suspicion that this person is trying to smuggle. The only condition which you can use to search the person is where there is no other person around of that same gender. So you don't say because, oh, maybe I'm customs and there's no other customs person of that same gender, let me search the person. If maybe NAFDAC is there or immigration or whatever, and there's a female, you can also, your envisage to be able to apply to that person to search on your behalf the person of that same gender, so as not to transverse the gender roles. Then the Act has also introduced credit card payments to reduce cash handling and corruption allegations. So obviously cash is still allowed, but credit cards is now the preferred and primary method of, or basically electronic payment methods is now the preferred mode of payment. Now, personal effects has been defined in the Act. Now, because this has to do with travelers, we have had so many cases where we have been sent to court because why? Because an officer probably, someone is traveling and they're asked to pay duty for an item, and they start to allege that, oh no, that item is my personal item. And then, you know, they just get into a squabble. But unfortunately, the problem is that this was not a problem of the officers or the travelers. It was a problem of the law, because the amount, the cap, the previous cap was a cap of 50,000 naira, which means that any personal effect that was over the cost of 50,000 naira, of course, was subject to pay duty and did no longer qualified as a personal effect. Realistically, that was ridiculous, because even if you take a look at the exchange rate, like what are you going to, if you convert 50,000 naira, what are you going to be able to purchase with that amount that you would then not be subject to pay duty? So what has happened in the Act now is that it gives the service the power to make regulations, so that it can make regulations in line with the existing economic realities. Look at the FX rates now. Every day it's flip-flopping. So how can a traveler then, you know, how do you know what you're traveling with that would now have the limit? So the Act has now provided, it has not put a specific sum, because even if you had said now, oh, let's put $5,000 or $10,000 as the cap on personal effect, what's the guarantee that within the next year or so, that even that $5,000 or $10,000, whatever the naira equivalent is going to still be tangible? So this is quite an innovation in the Act, is that personal effects now is going, as in the limit on what it is for a traveler to pay duty, is going to be subject to regulations that is made by the service. Now, intellectual property rights, this is just very simple. The service is just collaborating with NCC, Nigerian Copyright Commission, to enforce IP rights. This is because Nigerian Copyright Commission is not like a paramilitary agency or an agency that can be everywhere. So like say at the airport or so, they cannot be there. So they don't even know when people are doing smuggling that is infringing on Copyright Act. So what this provision is just saying is that the service can detain, arrest, or seize importations or exportations that infringe on the Copyright Act. But of course, it would then be handled by the officers of the Copyright Commission, but it is just because of the wide reach of the service. So it's like an interagency cooperation type thing. So they are just helping the Copyright Commission to enforce their IP rights. It doesn't mean that we're in control. It just means that we are helping them to enforce their mandates. Now, customs excise duties. You can see that the president suspended the 5% excise tax on telecom services and also signed the customs excise tariff variation amendment order and changed the tax dates from March 27, 2023 to August 1, 2023. All these things were done to reduce the negative impact of tax adjustments on businesses. Now, notable provisions under this Excise Act is Section 170, which imposes excise duties on excise manufacturing, and then Section 171, which provides 10% penalty for late excise payments. And then section 172 provides on excise duty amounts. Now, this is the excise part didn't really change a lot. It's just the increase of fines. So you can see a thing such as manufacture of spirits, which was previously provided for in sections 174 to 180, which was previously provided for in sections 99 to 100 of SEMA, is now 174 to 182 of the new act. And it provides that like unauthorized removal of spirits is a fine of 2 million or 6 times the product value. If you also take a look at the manufacture of beer, the penalties under the act is 20 million naira fine or 5 years imprisonment or both. And you also forfeit the goods that violated this beer manufacturing. In comparison with the SEMA, the previous fine was only 200 naira. So obviously we can see that it's from 200 to 20 million. That's a massive improvement. Then if you also look at the manufacture of tobacco and its substitutes, the penalty now is also 20 million naira fine or 5 years imprisonment. In SEMA, the fine was only 400 naira and forfeiture of the goods. Now, a new introduction in the excise part of the act is the manufacture of carbonated drinks. This was not previously provided for. An excise license is required for the manufacture of carbonated drinks and is also 20 million naira fine or 5 years imprisonment or both for non-compliance. But now, under this section, the Minister of Finance, Budget and National Planning is responsible for setting the regulations for the manufacture of carbonated drinks, and then the service just implements as is typical. Then there's also manufacture of other goods that are subject to excise tax. Violations carry a penalty of 5 million naira or 3 years imprisonment or both. You can take a look at sections 201 sub 2 for that. In SEMA, the previous fine was 400 naira with goods forfeiture. So it's just, you can just generally see that I've put a table showing the key penalties that are available under excise. Business after license revocation, 2 million naira fine or 2 years imprisonment. Failure to provide office space, that's for the officers that are in the excise realm, 1 million naira fine or 6 months imprisonment. Destruction or improper access, 2 million naira fine or 2 years imprisonment. Failure to keep records of your excise transaction, 5 million naira fine or 3 years imprisonment. So if you look at the comparisons with SEMA, you see that it was just really low fines of, I don't even think there's anything that's like 1,000 naira. It's just 2,400 etc. Now, when it comes to the enforcement and legal proceeding parts of the act, most of the provisions in the Nigerian Customs Service Act are similar to SEMA. Basically, the major changes are just increased penalties and more prison terms, and then the incorporation of the fines along with prison, which means that even though you're going to go to prison, you're still going to pay a fine. Now, one of the things that has been, two things actually have been introduced. There's now administrative and concession settlements, which means that you can now do like ADR or plea bargain outside of court. So if someone is found guilty of customs offense, you don't have to charge them. You can do a plea bargain. Maybe they say, okay, that they will return the item and pay a certain amount, and then you drop a terms of settlement, and then they can be allowed to go free. And also the protection of innocent people. If you take a look at sections 248, because this has to do with means of conveyance, anybody that has worked in enforcement will see that there are so many appeal letters. What's the problem? The owner of the means of conveyance will say that, oh, I did not know the driver did what he did without my knowledge. But you know, under SEMA, what it was is that everything is going to be forfeited, both the offending item and the means of conveyance. So what section 248 has now provided for is that if the owner of the means of conveyance can prove, you see, that's the thing, you don't just come and say, you have to provide, if you provide evidence that your means of conveyance was used for that offense without your knowledge, then that means of conveyance is no longer then subject to forfeiture. So I've done a general table. So you would see the new NCSA Act, the part that it deals with, the old parts of the SEMA, like I said, because the contents are quite similar. It's just increased penalties and fine. So basically, it's a very short analysis. It's a heavy law. It's impossible to do a very accurate review within a short time. I hope that maybe you would now be able to ask me specific questions that you have as to maybe what you don't understand or the import of certain sections, but this is just an overview of what the act contains according to the parts. Now, this law has just been implemented. There's no way that it is going to be a perfect law. It is in implementing the law that we'll now start seeing the shortcomings, and then a review can be done and amendments made. But yeah, that's it. Thank you very much.
Thank you very much for the insightful presentation. I'm sure the House will agree to the fact that she has done justice to this topic. And the fact that you are going to help us with the slides, we don't have to be opening SEMA to read from beginning to, well, not SEMA, Nigeria Customs Service Act 2020 to read from beginning to the end. I think you have done justice and we really appreciate it. Now, for questions, I'll yield the floor for members to ask questions. I have my questions like 2 or so, but let me allow our other audience to also raise their question. Let me be the last person to raise the question. We will try as much as possible not to keep you beyond 1 hour because I know you're a very busy person. So we won't. So any question, please? House?
Yes, please. Good evening, our distinguished and indefatigable Allah. Please, my question is with regards to section 14, which talks about the appointment of the Comptroller General. You said that. Pardon me? Can you hear me, please?
Yes, I can. I can hear you.
Okay,
Mr. Mewada, mute your
I
mic.
don't know.
Oh.
Yes. Where
Village
you
guy,
said
mute your mic. AY, your mic is muted. AY.
hello. Pardon
Okay,
me.
yes, now we can hear you. Yes.
My village people. I was talking about section 14, which provides the selection of the CG from within career officers. Does the section talks about who a career officer is as per say professional or general duty or a sort of is there any clarification to that effect, or just a career officer? That's what the section says.
Okay, thank you very much for your question. This has actually been this has actually been a cause of concern to many officers, and we've been asked questions. So you see, typically at the back of the law, if you see where we have section 281, that's the interpretation section that will I say that gives interpretation to things that have been provided for. But a career officer has not been defined. So now it is subject to interpretation. Hello?
Yeah, I'm with you, please.
Okay, yes. So it is now subject to interpretation because it has not been specifically outlined in the law. It should have been something that should have been put in the interpretation section saying that this is exactly what a career officer means. But if you look at that 281 in the interpretation, a career officer is not defined. So now it is subject to interpretation as to who or what is a career officer. Thank you.
Please, is still related to that question. Does the Act provide for transfer of service?
Transfer of service. What do you mean by transfer of service?
For
Like
example, as you are well
agent.
groomed in customs now, maybe if there is vacancy, one day you could decide, or the service would want, if the service would want to admit you as a custom officer, does the law provide for that?
Okay, right now there's no. At the moment, it's not specified.
Okay.
Yes. The employment, recruitment, that can be put maybe in regulations or whatever it is. But at the moment, your scheme, that's your scheme of service, scheme of employment. But the Act itself does not have any specific provision for transfer of service. The only thing that the Act has is, if you look at section 15 provides for other staff of the service, but not transfer. So I'll read it verbatim. It says, the board shall have powers to appoint such number of staff who shall be officers as deemed necessary for the efficient performance of the functions under this Act. The service shall pay its staff remuneration and allowances similar to other revenue generating agencies as the board may determine in consultation with the appropriate authority of the government. So there's nothing that's providing for transfer of service.
Thank you. Please, my second to the last question has to do with section 165 rather, which talks about personal effects. My network fluctuated at that moment. I don't know, is there a limit to which somebody could pay for personal effects, just like it was in the Repeal Act?
Okay, sorry. Like you said, your network went off. You see that I said that the limit now, if you look at sections 165(7), it has not provided for the limits, but it says that the limits will be provided for in customs regulations. So a specific sum was not codified because of the fluctuation of the FX rates. So it is for the customs itself to make regulations as to what the limit will be for personal effects. And I think at the moment, T&T is working on it, but then they can all change this limit or whatever. But according to this law now, the limit is going to be specified in customs regulations. There's nothing in the book itself that is putting a specific sum.
Okay, then the second to the final, please, where you talked about under controls, retention of documents. You did state that it is now 10 years. Does that mean that, for example, if say for example, I have imported a vehicle, perhaps this vehicle was a smuggled vehicle and I've been using it for 10 years, or perhaps along the way I lost the document and it's over 10 years, does that mean that customs is not duty bound to arrest such kind of vehicles owing to a non-availability of documents?
Okay, it's not let me just open that part. Sorry. When you talk about document retention, it's actually dealing more with the expectation of the documents from either customs or from the trader itself. So that means that, let me read it out for you. A declarant or a person who is directly or indirectly involved with the exportation or importation of goods, or acts as a customs representative, or is directly or indirectly involved with the storage or transport of imported or exported goods, free zones, or any custom control zone, shall keep all documents, information, and data related to customs matter for 10 calendar years from the date the transaction occurred, or the documents, information, and data were created. So we're talking about things now like, what's it called? Declaration form or whatever it is. Do you understand what I mean? Is that if you have initiated an activity with customs and 10 years from the date of that you created that document, you are still expected to be in possession of that document, as well as customs. Customs is also expected to 10 years from when we did that processing. Not that if somebody has done a declaration and the transaction has been concluded, and maybe 5 years later they write all those when they write that, oh, they want that document, then you say it's no longer in your system, you're liable, you'll be held liable by the law because you're supposed to have retained that document for 10 years or after. When it comes to smuggling, what they call it, illegality cannot rest on legality. So if you have smuggled a car, you cannot claim that you do not have the documents. I don't know. Do you understand the difference? Hello?
I think there's a relationship between what you are saying and what we did yesterday. Now, if you look at even the reason why you need to check document or ask for documents, it has to do with maybe post-clearance audit to see whether there is the level of compliance is okay or there are infractions or so. So which means, is the question, is a rider to his question. Are you clearly saying that now you can't, a PCA person can't, request for document or carry out an audit of documentation or declaration that is above 10 years? Is that the case?
No, it's not. It's talking about providing the information. Do you understand what I mean? It's not restricting the audit. It is talking, that's why it says retention. So it is talking about this provision of that document. Do you understand what I mean? This section 43 that we're talking about is talking about the document retention. So you're supposed to be in custody of that document. Your question now that you're asking is that after the period of 10 years, can an audit be conducted? Is that what you're asking?
Yes.
Okay, then if that's the case, let's go to section 36 because that's what deals with post-clearance audits. I'm coming, let me just hang on a second. Okay, so now the law is section 36 is what provides for post-clearance audits, but the law is silent on a time frame for this audit. It doesn't specifically state that there's a specific timeline. The only timelines that are provided here is where it is sections 37.7, where it's talking about if a person is being audited, they may within 7 working days after the conclusion of the audit forward a written explanation on any issue. But if I want to go back to your question, if you want to relate it, if you're saying that you want to conduct a post-clearance audit and you want to conduct that post-clearance audit 10 years after that transaction has occurred, the person can come and hide under this sections 43 to say that they don't have that document. I don't know if you understand the difference.
be a hiding place for. It will be a
Yes,
hiding place
exactly.
for
Yes, because the
person
person
not
can
to provide documents.
Yes. Because the post-clearance audit has not been given a time cap. So there's no limit, there's nothing in the law that is saying that you cannot conduct an audit after so time. But now, because Sections 43 has said that 10 calendar years from the occurrence of a transaction, or that documents, information, and data are created, that a person is not reasonably expected to be in possession of that document. If you want to conduct your PCA after that time frame, if a person comes under this provision and says that they don't have that document, then they cannot be held liable, as long as they can establish the date of the occurrence of the transaction, or that document was created, that it is after the 10-year time limit, then they are no more subject to provide that information and cannot be held liable.
Okay. Musa, is that the end of your question? You have another one?
No, the last one is on that section that talks about Sharia. That gender search. You know, of course, you talked about maybe there's no need for the question because there are exceptions. Because there are areas where, for example, in our operational areas, you realize that there are no female officers at all, kwata. And if you have
Yes,
to
that's why if you have to
exception.
search, that is
Yeah.
now an exception. So
Yeah,
that is an
yeah.
exceptional circumstance. So you can conduct a search under that circumstance, because then that is also, you have to also know that it's not that you just say, oh, maybe it's like as if she looks like she whatever. You have to have a cogent reason, so that if you're asked, so obviously if you see that it looks like that, as in there are obvious indicators that specify that this person is engaging in a customs offense, and you don't see a person of the same gender, then it is an exception to the general rule, and you can conduct your search.
Thank you.
Thank you very much. I have two questions. This is what I did on Friday, and I just really want to seek clarification. Now, Section 119, that has to do with sale, disposal, or destruction of goods. Now, if you go to Section 119, subsection 4, you will see the goods shall be disposed by public auction or tenders whose date shall be adequately publicized in advance through national newspapers, television, and the website of the service in English language. Now, what we publish, we are going to publish some of these overtime cargoes on Monday in 2 national papers. We are going to put it on electronic media, that is television, and it's already on our website. But the caveat we put is that 2 weeks from this publication, you will risk, the forfeiture of your goods or whatever. So, did we drive that 2 weeks from regulations? Because the law is silent about what period are you going to give for that person to come over and clear his good or risk the forfeiture of those goods. So I know we put 2 weeks, but I did not see any 2 weeks within the law. Then my second question is related to the TI, temporary importation. 1 year, 6 months, and 6 months, which makes it 2 years. Are you talking about the 1 year? Is addition, or is the initial 1 year that you import those TI before the 6 months and 6 months? I don't understand. First, you bring in TI for 1 year, then you are entitled to an addition of 1 year, 6 months, and 6 months, or you bring in TI 1 year, 6 months, and 6 months addition. That is my question. Those are my two questions. Thank you.
Please, just before she answers, I have a rider question to your earlier to your first question. Where did we drive the power of auction via direct auction sales? Thank you.
I'm with you. Sorry, let me pull up. So let's start with the TI question. Let me open sections 143. So you see that the first section 143(2) states that the maximum period during which goods may remain under the TI procedure shall be 12 months. Now it says that in exceptional cases, when the authorized use cannot be achieved within the allotted time period, which means that it has provided for that allotted time period is that initial 12 months. The service may extend the period for temporary admission for an initial 1 year and extend. Who wrote this thing? May extend the period for temporary admission for an initial 1 year and an extension of. Sorry, I'm coming. Hold on. So basically, the extension period is 2 years. Because if you read it, it says the service may extend the period for temporary admission for an initial 1 year. So that's the first one. And extension of 6 months. And then another 6 months if necessary. The previous, who is familiar with the TI procedure?
Have them, so many of them here. Barau,
All of us.
SD.
Yes,
So
yes.
you can tell us.
Okay, so what was the initial extension period for TIs?
6
It's
months.
6 months.
No, what was the total? Was it only for 6 months?
Twice.
Yes, you have like 2 years altogether.
So why I asked this question is that it is the same thing. It has just now been broken down because the total extension was for 2 years, right?
No,
And the officers
previously the
familiar.
extension
Extension
is
clear.
for only 1 year, meaning you will be allotted upon application, you will be given 1 year. Then if you come for extension, you will be given 6 months, then additional 6 months if necessary.
Okay, so great. So it is this same thing that has just been codified into the law. There's no difference. So that's why I said, you know, sometimes when you read, it becomes like as if it's different from what is applicable. It is the same thing that is applicable, but it has now been put into the law. That's why I said, let me read it, because so you are giving your TI for 1 year. If you apply, do you understand, for an addition, they will give you 1 year. That 1 year then can be extended for 6 months. Mute your mic, please. That 1 year, they can extend it for 6 months. Then if you say it's not enough, they can also extend for another 6 months. So it is just breaking it up. It is the same thing that is applicable, that was applicable, that is just codified into the law. It is not different. It has not changed. It still comes up. So what they're just basically saying is that the whole TI thing, it cannot be more than 3 years. Because when you're giving your TI, it's for 1 year. The first,
sorry, 2 years, I give 2 years, I be 3 years, sorry. The whole of it.
So yes, exactly.
Which one?
Sorry?
Because
saying?
the explanation, the way what you explained to us now is you made us understand that it's the dual time is 1 year, additional extension of 1 year. That is making it 2 years as a whole. And now you say the extension is 2 years. That is making it 3 years. So which one is which?
So everything, the whole TI process is 3 years. Now that 3 years is because your first TI is given to you for 1 year, right? What is on the TI is 1 year. That is the 12 months period that is talked about in 143(2). Extension is 2 years, but the 2 years is broken down. Your first extension, you'll be given 1 year. That's if you apply, you'll be given 1 year. If you apply for another extension, you'll be given 6 months. If you apply for another extension, you'll be given 6 months, but they cannot give you anything after that. There's no more extension after that. So it is still the same 2 years. But if you apply, they will they'll give you 1 year. If you apply again, they'll give you 6 months. Then they'll give you 6 months. So instead of just saying you are just going to be given 2 years straight like that, or 6 months into 4, that's why I said it is still the same thing that is in application, but has just now been codified into law. It is the same thing you explained to me, that I'm just telling you that it is the same process that's applicable, but is now in law. So if you say that you cannot, you have not, your TI, you have not finished using it, they will give you another 1 year. So that means you are getting the same period as what you were given earlier. If you apply again and say that, you have still not finished using it, then they'll give you 6 months. They don't give you 1 year now. They now give you 6 months. If you still say you have still not finished, then they give you another 6 months, but that's the final 6 months. So it is a total of 2 years. I don't know if I'm clear.
Yeah, it's very clear now.
Yeah, for you, every other person, I don't know, is it really clear?
Well, I think there is a
Clearer.
confusion in our minds.
So
Most of us,
TI is a total of 3.
but
Okay.
we'll resolve it. We'll look at what is obtainable. We have to sit down and look at that, because some are thinking it's 2 years. 2 years, 6
As a whole.
months, 6 months. Some are feeling it's the first entry is 1 year, then extension 1 year, then another extension 6 months, another extension 6 months, making 3 years. So, but
Your second explanation is the answer.
Okay, so no problem. So my second question.
Yes, your second.
And Musa's rider.
Your other question was as to the disposal of goods and the time frame, right? Sir?
Section 119, subsection 4, which stipulate that there must be a publication on newspapers, national dailies, television, and website for a period of time before these things are disposed. But what we place on newspaper, I saw a caveat of 2 weeks from the day of this publication. And also they tell me, that's why I put them, but I didn't see it on the law. So that 2 weeks grace period for people to come and clear their goods, is it a code, or is it a regulation, or is it a law, or whatever? Do we have any section of the law that says that? Then Musa had a rider that which section gave the Comptroller General of Customs the power for direct auction. I don't know whether you have even added the e-auction on the new act.
So, what they call it? So let me attend to your first question, then I'll go to the other question. So when you talk about section 1194, you see what it says here. It says, shall be adequately publicized. Adequately publicized. It does not state the specific. So this 2 weeks period is not derived from the law. Maybe that is your own, how do I call it? That's your own understanding of adequate publication in advance. Do you understand what I mean? The 2 weeks is not stated in the law. What the law says that it shall be adequately publicized in advance. In advance. It doesn't say you must publicize it within 2 weeks or within any time or whatever it is. It just says adequately publicize this. So I guess the time frame is derived from the powers that's be, but the law does not state that it has to be 2 weeks. The law just says you should adequately publicize it in advance. People can argue as to what adequate publication is, but the 2 weeks is not derived from the act. Then as to the first question, you can see that they have put that 1191, the service shall with the order of courts direct the disposal of goods by sale, destruction as prescribed in this act, or as the customs management may deem fit. So now that's where the direct auction part is coming from. The other one is with the order of court. That has to do with like overtime condemnation, basically. While the direct auction is the one that states as the customs management may deem fit. So you would see if it is falling under condemnation or direct auction. So that is, they are deriving that power from 1191. Okay, so next.
Any other question, or because I'm sure. Any question?
Just right now, just in continuation of still the questions with regards to disposal of cargo ownership. She made mention that after a certain period of 30 days or so, if owners or importers do not come forward to clear their cargo, that there are certain penalties. So my question is on that: what is the duration of cargo, after arrival at the port? At what point does it, become over time? Because you come around cargoes that are already tag abandoned, and then they get, untagged and all of that. So this is all the specification. What time does the cargo? What time is it valid for the declarant to come forward and declare cargo, and at what point does it become, overtime or government goods again?
Okay, you take a look at sections. Hello? You take a look at section 64. It's 30 days. Hello?
Yes.
Yes, 30 days is the time when any important goods remain uncleared at the expiration of 30 days from the date of completion of discharge. So it is 30 days. When a person that doesn't clear their goods after 30 days is now subject to a penalty of 1 million naira. And then that is when the proper officer shall cause all of such goods to be moved to a government's warehouse. So if they don't clear, in SEMA, it was 15 days, but now it's 30 days. So you have 30 days to clear your goods. You can take a look at section 60.
Okay. Please, can I?
They require permission of what the headquarters or what after 30 days what happens? Sorry, please.
So like I said, it is sections 64. If you don't clear, you see a proper officer, you would then move the item to a government warehouse. A proper officer is any customs officer that is appointed to work in that place. So you obviously have your documentations, you would have your area controller or whoever it is. If a good has not been cleared for 30 days, your area controller, the controller in charge, or whoever, AC, whoever is in charge of that, has the right then to cause that good to then be moved to the warehouse. But the person has 30 days if they have not applied for an extension.
Okay, thank you.
Yes, please, I don't know if you can assist to shed more light on section 273, subsection 1 to 3, please.
Okay, so you said sections 273.
Subsection 1 to 3.
Okay, this is just talking about re-examination and the timeline for re-examination. So you can redetermine declarations, classification, valuation, country of origin within 7 years of that declaration. So you have a 7-year period if you have a reason for that redetermination. So what he's just trying to say is that after 7 years and somebody has placed a declaration, if you have not done any re-examination or redetermination within that 7-year period, of course, after you have given reasons to the declarant as to why you wish to re-examine or redetermine what they have declared, then you are no more you just stick with whatever the original determination was. You can no longer change or say that you want to re-examine. Basically, that's what it's saying. It's just saying that any redetermination or of the duty to be paid or any re-examination must be done within 7 years of the lodgement of the goods declaration. After that 7-year period, even if the person, whether it was a fraudulent or false evidence, whatever it is, then you can't do that anymore.
Okay, because I was actually trying to marry that with the previous discussion as to the PCA timeline of the debated 10 years, 7 years. So I now saw this and I was trying to see if we can link them up.
Okay, no, this has to do with re-examination. That has to do with documents retention. You remember I told you that, so there's a difference. So that's one. So you can request for documentation can be requested for a transaction, but re-examination and redetermination of duty after 7 years cannot be conducted. That's why when I was saying that the two should not be mixed up, that just has to do with, you can request for documents for several reasons. It doesn't only have to be for what they call it. It doesn't really have to be for duty. Even for administrative purposes, you can just need a document, filing, whatever, all of that. So that is what that particular section 43 is dealing with. But what this 273 now is talking about, if you want to re-examine and redetermine what did they call it? A declaration that after 7 years, just forget about it.
Thank you.
Do we have any other question in case, if there's no any other question, I will invite CSC AY Musa for vote of thanks.
Go ahead, no question.
Okay,
Is there any section on PBD? Okay, no problem. Musa, the floor is yours.
In the absence of further questions, I want to, on behalf of all of us, express our profound gratitude to Ala Uche for taking out time to educate us on the Nigerian Customs Service Act vis-a-vis the repealed SEMA. Thank you very much for enriching our knowledge. Thank you very much for sharing this quality time with us. We will remain grateful forever in this. Thank you.
Thank you very much. We'll meet by 9 p.m. inshallah in the evening. Thank you all, and again, thank you very much for this opportunity. We really appreciate it.
Thank you very much. I wish all of you success in your exams. I'll share the slides with Mr. Mewada. If you need any further clarifications or a more elaborate explanation, this is just, like I said, just a condensed effort. I was trying to see if I could share let me see if I could share the documents here, but I'll just share with Mewada. I'm sure you're all in a group and he would transmit it to you. Thank you very much for the opportunity. I wish you all success. Wish you the best.
Thank you.
Thank you.
Musa, my salami to 419. Bye-bye.
Consider it done. He will deliver.
It's
He
just
will
that we
deliver
don't have the
Salah Ram to
opportunity
you.
to put a face to the voice.
Who is that one?
The band of Tetabi. Band of Tetabi Sana.
You have to see my face. Come to headquarters. You see my face.
No, they should pay me. They should pay me.
Because
I'm the only
you're supposed to
Yes,
put a face
please.
to the voice.
I'm seeing here. Oh.
Sorry?
See here. Oh.
You that did not give me salami. I beg, you have been dumped. Forget,
Okay,
I'm not
don't worry.
doing it.
He will deliver Salah Ram to you, not only meat.
I want salad cow. Salad
Oh.
salad.
Only cow? How about camel? Added to the cow.
No, for now, or pangolin. I want pangolin. Let me sell it. I'll make plenty money. All right, guys, no problem. Thank you. Good luck. Mewada would share the slides with you, and please, if you need any further explanations or whatever, I'm available.
For those of us who are in the amphibian part of the service, we one day pay you a courtesy visit at the headquarters.
All right, no problem. I'm on the ground floor.
Thank you very much.
You're welcome. Okay.
Barau Chirita. Okay, ta hita mako.
Ta hita.
To jama'a ina da sanarwa.
To.
Kun dai ga abin da ya faru a nan, aiki aka yi ba kaɗan ba. Kuma Vice Chancellor mu na yanzu, which happens to be the man behind everything, was actively involved in this process from the beginning to the end. And therefore we may not escape questions from this act, definitely.
All right.
But then the summary she gave was very, very insightful and tare aka fara da ita.
Anche VC din was part of it, so you don't need to answer question from him.
Assalamu alaikum. Oga Barau, da Allah a yi sharing video din saboda mu sake rehearsing.
Immediately, inshallah.
So kuma inshallah is good ma mu samu wasu questions based on recorded video din saboda mu sake tattaunawa akai.
Inshallah.
Oga Barau, da Allah if possible har da na jiya ma videos.
Duka za a sa. Duka.
Ewa Musa.
Yeah.
Shed more light on what you were saying before. Amma kun gane na yi mata shiru akan TI din nan. Ku da kuke operations ku ya kamata ku mana magana me what is obtainable in the field.
Amma dai ta gyara daga baya. Initially ta ce shekara.
Ta gyara.
Ta ce shekara.
Amma ita ba ta insist shekara uku ne fa.
In kuka duba dokan ko? In kuka duba
insist ba shekara biyu ce magana.
Addition take magana.
In kuka duba dokan ko? Akwai yanda ya faɗa gaskiya dokan ne ya gwada abin gaskiya shekara uku ne.
Shi ne abin
aiki. Amma masu gida Allah nawa ne shekara nawa ne?
Ita fa abin da take nufi shine abin da ake nufi da ukun nan shekarar farko in ka zo za a baka shekara ɗaya. So menene extension? Saboda na iya twisting question din me extension? Extension is 1 year, 6 months, 6 months. To amma initially in ka zo a baka TI na 1 year.
3 years kenan.
An fahimci 3 years kenan. Ka fahimci a turancin yanzu an ce maka if somebody is entitled to extension na nawa?
1 year.
Extension is quite different from initial 1 year da za a baka.
Okay.
Ka gane kana cikin abu a za a confusing ɗinka.
Because I'm confused. Har aka gama confused wannan question din. 3 years kawai. 3 years kenan.
SG ka koma lafiya?
Lafiya kalauran ka daɗe. Amma dai na sake dawa Abuja ma sai gobe zan koma.
Okay, mun yi misin ninka kwana biyu a platform.
Yawa da Allah ka SG muna neman ka wallahi intelligence ɗin nan.
Insha Allah ran talata zan mana shi. Ran talata zan yi already ina da slide.
Talata? Okay. So to mun gode sosai da sosai.
To mun gode PRO wallahi da kokarin da kuke ta yi akan abin Allah kuma ya sanya a ƙarshen ta dukkan mu yi farin ciki da outcome din.
Amin. Then one more thing ba. I have this proposal. I don't know why won't at the end of maybe each session na muka yi maybe kamar wannan NCS Act, if we can come up with the possible questions that we